We are hot off the heels of the historic Third Continental Congress, and I am delighted to be joined tonight once again by Larry Klayman and my second favorite attorney, no offense, John Snyder. Gentlemen, welcome to the show.
Our pleasure.
Thank you.
John, people saw you last week when we were reviewing some information from the Eastern District of Michigan. We're going to be talking about President Trump's class action lawsuit tonight. But before we do that, I wanted to remind everybody that if they missed the Third Continental Congress, they can go back and review the video content in a lot of different ways. You can go to the Freedom Watch YouTube channel and watch the full 11-hour session. I've been breaking it out into the different individual speakers, and I'm going to continue doing that. So you can watch Sheriff Arpaio and Ambassador Alan Keyes. People can also see it on Crowdsource the Truth or on the new Citizens Grand Jury YouTube channel. This is a new YouTube channel I've created so that the forces that are trying to ban Crowdsource the Truth and the efforts that we're undertaking with Freedom Watch, they can't get us off the internet so easily. And I do want to remind people to visit freedomwatchusa.org and support Larry and his team at Freedom Watch. This Third Continental Congress was an absolutely historic event, and these things take so much effort and so many resources. I hope that people who watched and enjoyed that show will donate to Freedom Watch. I also want to let people know that if you're in New York and you need a trial warrior, an attorney, John Snyder is an excellent commercial litigator, and he can be your advocate as he is mine. We're going to be talking about President Trump's lawsuit tonight, gentlemen. And, you know, the left-wing mainstream media has been generally maligning it. Legal analyst on CNN, ironically best known for having no briefs, Jeffrey Toobin, calls this thing a dopey lawsuit. There are things about it that people have a lot of questions about, but I wanted to ask you gentlemen some specific things because I think it actually does raise some important points. Now, Larry, I know you've been extremely busy and you're still there in Philadelphia, but the most important aspect of this to me is that it's challenging CDA 230, but it's basically saying that Twitter is acting as a government agency because people, including Kamala Harris, Adam Schiff, and others, have acted to compel Twitter to stifle Donald Trump. And in carrying out the wishes of Congress and other government actors, it's basically saying that Twitter is itself a government actor and should be subjected to, having to stick to the First Amendment. A lot of people tell us, Larry, that these are private companies and they don't have to adhere to the First Amendment. You might have more experience than any other single attorney in some of these social media lawsuits. Can you address that aspect specifically?
Before I get to that, Jeffrey Toobin is back on CNN now, is that right?
Yes.
He's finished masturbating on Zoom. Is that how he got back?
I don't know if he's finished, but he's back.
Right. I mean, this idiot got caught masturbating on Zoom. I mean, unbelievable. When I won the NSA case, by the way, twice, Jeffrey Toobin with Don Lemon and some other moron that was on there called me that I had a tinfoil hat. Okay. And so Jeffrey Toobin is not the expert here. I'm surprised they brought him back. It's a disgrace. In any event.
I mean, his commentary tells me, Larry, that he didn't read the lawsuit. And I know I just invited you on the show. You haven't had a chance to read it either. But you're not on CNN, and I wanted to ask you that specific question. Does Congress compelling Twitter?
Jeffrey Toobin is a hardcore member of the Marxian Jewish left. You know, we're Jewish too, so nobody can say we're anti-Semitic. So he's going to favor anything that would further the interest of his leftist brethren in the White House and the Democratic Party and everything else. He's a hack. But in terms of Trump's case, what he's going to have to prove is that Twitter, YouTube, and Google are in fact agents of the government. Now, it's a novel question whether or not constructively someone could be an agent if in fact no one has been designated as an agent. But I guess, if you quack like a duck or you bark like a dog, or you meow like a cat, you may possibly be all those things. You may be an agent. However, the problem here is that there's no federal judge in this country that has the courage, particularly when Donald Trump brings a case, to rule in his favor. So as a practical matter, it ain't going to happen. Two of the judges that he drew he filed in the Southern District of Florida, which is a heck of a lot better than filing in Washington, D.C. I mean, that's a complete dead letter. But he drew Michael Moore, who I had when I represented the family of Elian Gonzalez and also peaceful protesters that we talked about at the Third Continental Congress that were outside of Elian's uncle's house when he was taken back to Cuba, when he was taken at gunpoint. Michael Moore is a moron. Okay, that's unfortunate, but it's true. And he sent Elian back to Cuba. And the other two are Obama appointees. So, I think that Trump's case, has some merit. I really do. But there's no judge in the country that's going to rule in his favor. That's the reality.
Yeah. One of the most compelling and original aspects of it here, Larry, is that they do cite specific tweets from Democratic lawmakers, including Adam Schiff. One of the examples they're giving here as Congress compelling Twitter to act on behalf of Congress is this tweet from Representative Schiff, May 5th, 2021. There's no constitutional protection for using social media to incite an insurrection. Trump is willing to do anything for himself, no matter the danger to our country. It has a lot of different tweets that they cite from Kamala Harris, from Michelle Obama. Here on January 7th, right after the incident at the Capitol building, Michelle Obama puts on Twitter, "Now is the time for Silicon Valley companies to stop enabling this monstrous behavior and go even further than they have already by permanently banning Trump." So we do have government actors compelling Twitter to do this. The suit also cites various congressional hearings where they were grilling these guys and threatening them with breaking them up. Does this create a situation where a private company can be treated as an extension, kind of a government entity by extension?
In theory, that's correct. And that would be state action. So that's what President Trump is trying to allege. I suspect he's also alleging civil rights violations, not just with regard to the First Amendment, but discriminatory behavior. Now, there is no discrimination currently with regard to political ideology and belief, but he could allege that he's been discriminated against, based upon his race or his sex or his national origin or those kinds of things. So there's a great opportunity here to get some rulings and perhaps take it up to the Supreme Court on behalf of Freedom Watch. We've already brought cases for Freedom Watch and Larry Klayman, that's me, of course, and Laura Loomer, went all the way to the Supreme Court. Justice Thomas said that our antitrust case had merit, but no one else on the court had the guts to accept certiorari and review it. And that's ultimately the problem. But I'm probably going to be intervening in this case because
that would be great.
It is a novel case, and I am a lawyer in Florida. So, I hope that President Trump will prevail. But, with these judges, two Obama appointees and Michael Moore, he's not the sharpest knife in the drawer, even though he was appointed by H.W. Bush.
Now, hey, Larry, another good point. Yeah, John, please weigh in.
Oh, yeah, no, I was just going to say that it's interesting. I just took a look at the complaint, and it appears it's just two claims. One is First Amendment, saying that it's a state actor, and second, unconstitutionality of 230. That's it.
Right.
And as far as I'm concerned, Trump should prevail. But let's see what happens.
Let me ask you guys about some of the finer points, John, because here's another example that they bring up, is that Twitter is working hand in hand with the CDC, which, that's a whole other show, whether that's a federal agency or not. But it is essentially a federal agency, and they're saying that by partnering with the CDC and Twitter acting on behalf of the CDC, that it is a de facto government agency. How do you feel about that, John? It seems like a new angle on this, doesn't it?
Well, there's a whole line of case law that people don't seem to remember, but I'm sure Larry knows about it, which is, the old company towns. And those cases all said that even if the company owns the town and owns the store and owns the houses, you still have First Amendment rights because it's still America. You know, and there was another case, I think in the 70s, involving a shopping mall and involving leafleting. And they were trying to say, well, these people can leaflet, but these people can't because we don't like their leaflet. You know, and the court in that case said, no, it's even though you're private property, you're serving a public function, and therefore we're going to treat you like a government actor. So it wouldn't be the first time in the world this happened. However, I mean, you know, I tend to agree with Larry. You know, the idea that we're going to get a judge who's going to have the courage to do this, I'd like to think we would, but you know, I'd be putting hope before experience.
Yeah, in
I was
fact,
a little bit.
Much of our
Sorry, Larry.
Third Continental Congress was talking about judges. My book, It Takes a Revolution, goes through my experience as a trial lawyer 44 years. And again, it was Jefferson who said, federal judges, unelected, unaccountable to the people, will turn into despots and tyrants and cause another revolution every 20 years or so when people rise up. And that's what they saw, you know, on January 6th. They saw federal judges basically not even giving Trump a hearing. And that was the coup de grace. That was the icing on the cake to a perception by the public, at least conservatives, people of faith, and those who believe in the vision of our founding fathers, that the government is totally corrupt. And as far as the judiciary is concerned, from my standpoint, they're the most corrupt of the three branches. I agree with Jefferson. They turned into despots and tyrants over time because they're not accountable to the people. They should be elected, not appointed with political campaign contributions, which are basically just bribes to get them on the bench for special interest groups.
Absolutely. Now, there's another strange thing about this. I was pretty down on this when it came out yesterday because my feeling is it would have been nice if President Trump had done something about all this stuff while he was president so that his actions would have some bite. Now he's essentially just a billionaire celebrity fighting them in civil court. He's going to have all the same kind of challenges, Larry, that you and Laura Loomer and all of your clients have had. But I've got some more specific questions for you guys because this is posed as a class action lawsuit, but so far the only plaintiffs listed are President Trump himself, a person who I have never heard of before named Linda Quadros, and very disturbing to me, the American Conservative Union. So I think President Trump is hoping that more class members will join, but what can you guys say about this in terms of it being a class action lawsuit?
John, go ahead. I'll weigh in after you. I took up
Sure. To me, it doesn't make that much difference who the class representatives are. They have Donald Trump. You know, that to me is from an optics point of view, makes it very legitimate. Beyond that, the American Conservative Union, I don't know much about.
No, well, there's a reason for that. Okay, the American Conservative Union is using this for fundraising. They are the lobbyists that put these limited, to be nice, Trump judges on the bench, recommended them, run by Matt Schlapp, a very corrupt individual, frankly. And, this is just fundraising, and Trump is using ACU to raise money for himself as well. So that's probably what it's about.
Larry, do you anticipate any legal problems for President Trump by sort of hitching his wagon to CPAC and ACU and the American Conservative Union Foundation? Charles Ortel has identified numerous elements of evidence of serious financial fraud related to these organizations.
Well, I don't know about that, but I do respect Charles, and I respect his ability as an investigative journalist. And I have my own experience with ACU, as you do as well. They are, it's pay to play with ACU in terms of people who get to speak and who give speeches. You were physically removed from ACU because they don't want you to see what they're doing. So where there's smoke, there's fire, but it's a very corrupt organization, ACU. There's no question about it. And in fact, they even opposed Trump, when he ran in 2016 initially. They were backing Ted Cruz and others. And when Trump won, very opportunistic, like Chris Ruddy of Newsmax, frankly, who gave $1 million to the Clinton Foundation, they came around because this is the way they jingle the change. And unfortunately, conservatives, take it hook, line, and sinker, and they think this group somehow is the is the be-all and end-all of the conservative movement. In fact, it's a big thorn in the side of an honest conservative movement.
But they've become so powerful, Larry, you almost can't be a conservative candidate without their endorsement.
Yeah, no, it's unreal. I mean, it's a smoke and mirrors. It's a tremendous public relations agency. Schlapp, by the way, was caught selling a $750,000 pardon to someone in the last days of the Trump administration. He promised him he could get him a pardon, took $750,000, didn't get it, but pocketed the $750,000. This is what you're dealing with.
Yeah, that was, I think the guy's name is Parker Petit or something like that. That was a real serious situation. And there's other things that have gone on with the American Conservative Union that are very disconcerting. I've been trying to get Matt Schlapp to appear on the show to answer these questions, something that he is obligated to do, but has refused to do so far. So I'm troubled by that. I want to turn, if we can, as John pointed out, there are just 2 counts here. The first being a First Amendment violation, and they're targeting 47 USC Section 230, the famous Communications Decency Act. John, what do you think about the merits of this claim here? Is it unconstitutional?
Well, so what they're saying is that the deplatforming of Trump and other people at the behest of government agencies turns Twitter's act into a government act. I mean, the answer is nobody knows because there's going to be some law made in this case. But I think it's going to be very interesting, and I hope it at least gets up, to an appellate court where it gets a good treatment, because there is a question of at some point the degree of cooperation will be such that it does turn into a state actor and has to comply with the First Amendment. And I don't know exactly what that point is. Go ahead, Larry. Sorry.
If this case gets to discovery, which judges are these days not allowing on the federal level in particular, they're misinterpreting a case called Bell Atlantic versus Twomey. They do it intentionally, which says that if there's any plausibility to what you plead in a complaint, it must go forward to discovery and potentially a trial before a jury, if you ask for a jury trial in particular. If they get into discovery and are able to get into the files of Twitter, Facebook, and YouTube, God only knows what they're going to find. And I believe they will be able to prove, if they can get to discovery, that these companies are acting as an agent, of the government.
Yeah. And Larry, in your role as a DOJ prosecutor early in your career, you were very involved in the breakup of the big telecom companies. Why hasn't something similar happened with Google, Twitter, all these things?
Well, it did. That's the lawsuit that Laura Loomer and I brought. And it went to the Supreme Court, and Thomas said it was valid, it was well pled. But no one else on the court had the courage to take it. Thomas said, well, this perhaps can be revisited at a later time. He bailed out too, in effect. But it was a valid antitrust lawsuit. We claimed that this discrimination was done in parallel. It's kind of like parallel pricing in an antitrust case involving price fixing, that they were colluding, they were acting in concert and restraining trade. And also collectively, they had a monopoly. We sued Google, YouTube, Facebook, Apple, Instagram, the whole lot of them. And it was a very good case. But these courts, don't want to address these issues. They don't want to stick their neck out. I think they're afraid of retaliation, that these big tech companies are going to go after them and damage their reputation. But they are establishment people, you see, and they don't think creatively. They want to get hot potatoes off their desk. They have lifetime tenure, they think. They really don't. Under the Constitution, they serve for good behavior. They have nice pensions. They're well paid. Hey, why rock the boat? We're having a good time. A funny story about Justice Thomas. When I first met him many years ago, I walked into Barbara Olson and Ted Olson's house when we triggered the Chinagate scandal. No one knew me at that time. I was just becoming known. And Justice Thomas was on the other side of the room. And I walked up to him and I said, Justice Thomas, it's a real honor to meet you. And he said, well, Larry, it's a real honor to meet you. I wish I was doing what you were doing. I said, well, what you're doing is pretty good. You're Supreme Court Justice. He said, but it was better when I was on the DC circuit. I could go over to Union Station, get some French fries, take it easy, and now I just push paper. I say that to say that these judges have it good. They don't want to stick their neck out. It's a great job. Lifetime tenure, great pensions. Don't worry about anything. Just basically do a number on litigants.
Well, right. And also it's going to get them into a morass of technology issues that they're not competent to even begin to talk about. And they're afraid of it.
That's true. An important point. Now, so do we think, Larry, that this opinion from Justice Thomas will come into play in the Donald Trump versus Twitter lawsuit?
It could. And there was also an opinion by Judge Lawrence Silverman, another jurist that has some integrity on the DC circuit a few months ago, where he just ripped into a big tech and the fake news media. So there are at least a couple judges who recognize that something needs to be done and the courts have the power to do it.
Right.
Silverman was a dissenting opinion, just like Thomas. It was not the majority on that ultra-leftist court.
Yeah, it's a shame that Trump didn't do something, as I said, while he was president. So it's an interesting thing, this Communications Decency Act, Section 230, because it was created in 1996 in anticipation of the rapid growth of the internet. And John, as you know, you're the CEO of an artificial intelligence company that's geared towards law firms and streamlining discovery and helping people use technology to basically bring law into the 21st century. A 25-year-old law based on technology might as well be 1,000 years old, right?
Well, I think 230 actually was a pretty good deal. I mean, it was a pretty good bargain. It was, if you are merely running a platform, you're selling pens and paper, you're not responsible for what people write with their pen and paper. And that's fine. There's nothing wrong with that. What happened is that, Facebook and Twitter, they stopped being an open forum and started becoming a curated walled garden where, more and more they narrow the scope of what can be discussed. And at that point, I don't know that 230 should be struck down, but they should be declared outside of the protection of it.
Yeah, I agree with you on that. And I think that this is an area where the Trump lawsuit misses the mark. I was actually very impressed by the points that it made, raising the issues of Adam Schiff and Kamala Harris and other government actors, the CDC, compelling Twitter to do stuff. I think that is an excellent point. But there's a lot of language in this CDA 230 under this Good Samaritan section. As you said, Verizon doesn't say, hey, John, I don't like what you were talking to Jason about on the phone, so you can't have a phone anymore. They're just providing the network. And it's got language in here about acting in good faith and stuff like that. So in other words, if someone's putting death threats on the network, yes, they can remove that. And, I forgot where I'm looking for this exact, it says good faith in here somewhere.
Yeah, there it is. You got it.
You got it?
Any action taken in good faith to restrict access for obscene, of what the provider considers obscene. So that language obviously needs to be tightened up, and it can't be
too vague, right?
Well, it says what the provider considers obscene. It really just opens the door for Twitter to say, well, we consider this to be objectionable, but we don't consider that. And, that's all based upon their own subjective ideology, really.
Yeah.
And
this really gets us. Please, Larry, continue.
No, that's a very good point that Sean made. It's in the eyes of the beholder, what's pornography. That's
right.
A famous ruling. I forget which justice that was.
People versus Larry Flint.
That was
it was Potter Stewart.
Stewart, yeah.
And for years after that, people would mail him stuff and ask him whether it was pornography.
But see, this is really what it comes down to, because when the Trump lawsuit gets to all this stuff about 230, throughout his presidency, Donald Trump was saying he wants to abolish Section 230, but I actually don't want to see that either, because, you know, I am running an interactive computer service here. Crowdsource the Truth is a platform where a lot of different guests come on and share their opinions. I don't necessarily agree with those opinions, but yet I, as the operator of this platform, am often subject to the punitive actions of these social media companies for things that are said by other people. And some of this stuff comes into play in some of the lawsuits that I've been defending. So it's an interesting thing. The other count in here, John, is they want a declaratory judgment. Well, this is of the unconstitutionality of 230. So it's the First Amendment of stifling Donald Trump and preventing people from being able to communicate with him on Twitter, and then this constitutionality. What do we think we're going to see as a result of either of these two counts, or it's just too early to tell?
Larry, you want to go?
Well, it's too early to tell. This thing's going to be bogged down in the courts for quite a while. Here's the way it goes. The other side is going to, they've got 30 days to respond. They'll ask for more time to respond. And then they'll move to stay discovery. The judges will sit on it for months and months and months. And if Trump's lucky, he'll win with regard to a motion to dismiss, but he probably won't. And then it'll have to go up on appeal, and it'll go through the 11th Circuit, which is highly leftist, which makes it even more unlikely that anything's going to happen at that level. And then Trump will then have to file a petition for writ of certiorari with the Supreme Court. So it'll be years before anything happens. It'll be long after the elections, in all likelihood, in 2024. So, it's more of a statement by Trump. But you're right, Jason. You had it right. I mean, the president controlled the Justice Department, and Bill Barr, the former Attorney General, on the eve of him leaving, the Antitrust Division finally files an antitrust suit, against Google. I mean, and it went nowhere. It was a very weak case. It's just sitting there. The FTC and some of the state's attorney generals have tried to bring legal actions. And a judge in the U.S. District Court for the District of Columbia, Boasberg, threw it out. He allowed leave to amend. This was just last week. Boasberg, highly leftist, we talked about him at our Third Continental Congress, wouldn't even let Judicial Watch and Freedom Watch get a picture of bin Laden dead, and there were no privacy rights, among many other things. I've had the guy before. He's a political hack, like every other judge in that courtroom, frankly. And it's not going to... It's very unlikely that Trump's going to get beyond a motion to dismiss, but I think it's a valiant try, and I give him credit for doing it. He should have done it much sooner. I said this throughout. You know it, Jason. I said he always had the power even to bring cases as a private citizen while he was president, and he had the prestige and power, to put behind it, and he didn't do it.
And
it's probably too little too late.
I think I agree with that, Larry. There's been a real negative reaction. No one's surprised, of course, when the Washington Post and the New York Times and CNN say that the tech lawsuit is a joke. I haven't had a chance to read this Washington Compost article, but they do say that it raises a serious question. So perhaps it will move the ball down the field. There's one other question I wanted to ask you guys. And John, I had raised this briefly, and perhaps I'm seeing something that isn't there. But today, there was a letter from the clerk of the court that was sent basically saying that there's lawyers involved that need to appear pro hoc vice, that they're not embarred in the Southern District of Florida. John, I think you've had more of a chance to look at this than Larry. Do we know what this thing is all about?
It looks like something that's just automatically generated by the clerk's office to notify lawyers who look like they want to participate in the case that they have to get pro hoc in. I've never seen a letter like that, but I don't think I've ever done a case in the Southern District of Florida.
There are some courts, and I practice there a lot, but I don't frankly remember whether it works this way in the Southern District because I am licensed in Florida. But there's some courts that allow you to file and give you a certain period, a grace period, to move to get into the court on that particular case. And that's called pro hac vice. So that's probably true in the Southern District of Florida. There are some good judges in the Southern District of Florida. Unfortunately, Trump didn't draw any of them.
Larry,
I'm
just
confused by this.
quick question on something. You mentioned 3 judges. Why 3 judges?
He filed 3 separate lawsuits.
Oh, okay, got it.
Yeah. 2 Obama appointees, you can forget about that. That ain't going to happen. And Michael Moore, maybe somehow, he might have an epiphany and decide he wants to stick his neck out, but he certainly didn't with Elian Gonzalez and send him back to Castro's Cuba.
Why can't they find somebody who lives in like Oklahoma or something? I don't know why they have to file it in these even Southern District of Florida.
Well, it's a whole lot better than Washington, D.C., regardless of what happens.
Yeah, anywhere's better than that. But.
And Trump lives in Florida. I mean, the thing that confused me is that, this indicates that the law firm that he's using, Vargas, Gonzalez, Baldwin, DeLombard, they're in Coral Gables, and it's in federal court because of the federal question, U.S. government, not a party. So I guess I missed those other lawsuits. Maybe this pro hoc vice letter is talking about lawyers in those other lawsuits, but you'd think that a lawyer would know that they have to request to appear pro hoc vice if they're not embarred in Florida, right?
Yeah, except that's for sure. But it could be, as I said, that, and most likely is, that the Southern District of Florida will allow you to file and then give you a certain period of time to move in pro hoc vice.
Yeah.
Right. Now, Larry, I know you're very tired, as am I. We've had an extremely busy several days putting together and finally completing the Third Continental Congress. People can still watch that on a variety of different channels, and I've been separating out the individual speakers. If you haven't seen Larry's introduction or Sheriff Arpaio's keynote speech, now is a great time for people to watch that. We're going to have to keep our eyes on this social media lawsuit from President Trump. Anything either of you guys would like to cover before we wrap it up tonight?
John, go ahead.
Yeah, the bigger picture, because the question is, we have these social media platforms and search engines, and they exercise such great control over our ability to access information. And we can all see where it's going. And the question is, what is the best approach to turning it around? And 4 years ago, I pretty much gave up on the legal system as a means of doing that. And I think Trump's going to have a bunch of problems that, Larry can talk about, I can talk about. The court systems are just not set up to regulate social media platforms. And given the political structure and given the influence that they have and given the nature of the people who end up on the bench, generally speaking, it just doesn't seem like it's going to work. And so that's been my big thing from, and part of why I have sort of, I haven't left the law, I still practice, but I've gotten very deep into the world of technology and artificial intelligence, is because the way that we fight this is not by going to court. The way we fight this is we can build any technology we want. Nobody stops us from building any technology we want. We can build a better technology than they have. And their business model, the business model of all these tech companies, is very fragile. My suspicion is by the time you finally get to the Supreme Court and get your ruling, many of these companies will be either defunct or on their way out, and there will be other companies that will be rising up. So, what I would say is people who really care about this problem start focusing less on litigation and more on building better tech that people want to use, that is built from the ground up to encode and promote American values.
John, very well said from John's perspective, and I agree with him 100%. From my perspective, as what we did in the Third Continental Congress, we need a new government. I mean, that's the bottom line. And we're going to be deliberating in the next 2 weeks. I went on a show today and someone said I committed treason by saying that, a complete idiot. Okay, we're not talking about insurrection against the government or physically going against the government, but the American people need to form their own government. And we hope, that people will join us with that because, as in 1776 in our Declaration of Independence, is that when the government no longer represents the people, they have a God-given right under the laws of nature and nature's God to alter or abolish that government and to form a new government. This government is not responsive to us, whether it's with regard to big tech, whether it's regard to immigration, whether it's regard to balancing the budget and not bankrupting the country, whether it's with regard to forcing us to take vaccines in effect and endangering our health. You can go right down the line. We have no government. So it's up for us to step up to the plate and form a new one. And we can do it. And with John's help, with artificial intelligence and alternative methods of communicating with the American people, as I've said, and I don't even mean it facetiously, leave the criminals in Washington to commit crimes against each other. We're out of there, boys. It's over. You don't represent us.
Right.
Forget the scandal industry, Larry. It takes a revolution. I don't know if you guys realize this, but it has actually become illegal to play with Legos.
I saw that.
Has seized a fully constructed
Jeffrey
U.S. Capitol.
Apparently for Jeffrey Toobin, it's not illegal to play with yourself. So apparently he's back on CNN.
Exactly. Well, gentlemen, thank you both so much for joining me for this late night review of this really intriguing lawsuit that some people feel Donald Trump is just using as a fundraising tool. Some people feel he's using it as a political tool. It does raise some interesting and important questions. It does have some kind of disappointing deficiencies. We'll have to see where it goes. People can tune in to the Citizens Grand Juries. We'll be resuming with the weekly show very soon. And don't forget, you can become a sponsor of Crowdsource the Truth by going to subscribestar.com/crowdsourcethetruth or patreon.com/crowdsourcethetruth. And don't forget to visit crowdsourcethetruth.com, where you can sponsor the Counter Lawfare Fund. Help me and John fight lawfare in federal courts. It's going on right now. Thanks so much, everybody, for tuning in. Larry, John, thank you guys.
Jason, you did a fantastic job at that Third Continental Congress. I want everybody to see what you've done. So go to freedomwatchusa.org and crowdsourcethetruth.com and watch it and take it to heart.
Absolutely. Thank you, gentlemen. Have a great night, everybody. I'll see everybody tomorrow.
Take care.
Thanks. Nice to meet you, John.